Hello, everyone. Good morning and welcome to Privacy Kitchen. It's the 19th of January 2021, just to date this, when people are looking at the recording later. This will go onto our YouTube channel. And I'd like to give a really warm welcome to our guest chefs. I'll ask them for intros very shortly. Shad and Matthew, delighted to have you here. It's a great panel of guest chefs. We've got all the ingredients here, different views on data subject rights. This is going to be fantastic, in particular on the access right and lifting the hood on that. So I'm Robert Bohr, the founder and CEO of Keepable. We started Privacy Kitchen to give really sort of non-judgmental, very practical discussion and advice on GDPR and all things privacy, because it's not just GDPR. And so this is one of our Gigabyte sessions. It's a 45-minute round table. Do feel free to put questions up into the chat. And with that said, could you give us an introduction, please, on yourself and League Lions?
Sure. Hello, everyone. Thanks, Robert, for hosting this and inviting me. I'm Shad Kayani. I'm CEO and founder of League Lions. And League Lions really specializes in data protection and really offering sort of bespoke, affordable solutions for businesses and for DPR services. And my experience spans over 20 years working with all different companies, organizations, dealing with many data subject requests and many war stories to share today. So yeah, looking forward to the session. Hopefully we can add some value to people in the industry that work with DSARs.
For sure. Thanks very much. And Matthew, could you introduce yourself and content capture, please?
Yeah, Robert, thanks again for inviting me on. My name is Matthew Barnes. I'm a co-founder of a company called Content Capture Services. We process as many SARs in the UK probably as anybody. We've been doing it for 23 years as a company, redaction for 10 years, mainly freedom of information requests up until about 4 or 5 years ago, and then subject access requests, and we offer those throughout the English-speaking world. Yeah, I mean that's basically it. We can help. We offer a fully outsourced service, and I think we can balance out some of the needs of the marketplace, whether you want to do it in-house or whether it's something you look to outsource.
And I think you've raised a really interesting one actually straight off the bat there in terms of the timing and the importance of DSARs, because they've been around for decades, but it's really GDPR that's turbo boosted it. So you've clearly found that in your practice there at Content Capture.
Yeah, absolutely. It was quite slow in coming actually, because we were obviously always been lucky to be a busy business, and the freedom of information requests and just general legal redaction, medical documentation redaction, and then obviously we saw GDPR kind of flagged up, and a little bit like kind of the ticking time bomb of the millennium bug and things like that. Everybody got all excited.
Yeah.
And, you know, we sort of counted down to it. We sort of resourced for it. We thought, well, how many more are we going to get to, data subject requests? And actually, it was a very slow start. I think as much as anything, PPI kicked it off. Lots of people putting PPI claims in. And when they looked at how they did that themselves, they realized, well, the first thing that the PPI company do is put a subject access request in to find out, sort of what debts or things like that a bank might hold on you. So we tended to find it was that as much as anything that kick-started a flow of work. And it's sort of gathered pace, all the way along. And then obviously COVID, very sad situations come along, and that's pretty much shaped the last 12 months now. So it's a little bit difficult to say where the trend would have gone from the start of GDPR with what's coming with COVID. I mean, our search terms now that relate to a SAR are things like furlough, a word that probably none of us had ever heard of before, PPE, those sorts of things. So yeah, it has been very much a changing thing over a decade.
Yeah, I was going to just add to that as well. I think it's a really good point, because you're right, Robert. It's been around since 1998. Data subject requests have always been there. I think what's probably changed is people are a lot more informed. And I think Cambridge Analytica probably kicked it all off, where people suddenly realized that their data is being shared without their knowledge. And I think that was probably a turning point where suddenly people are a lot more informed. And I think from my experience from, pre-GDPR day into GDPR world, and where we are 2 years in now, it kind of feels like it's been a bit weaponized as well. People previously were getting requests just for information purposes, perhaps, or legitimate reasons. And now it's very much like, well, I'm not happy with this person or this company, or I'm employed by this employer. I've been let go here. I'm not happy with the way I've been treated. I've put in a DSAR. Let's see what I can get. So a lot of them have been weaponized, unfortunately, and it certainly is a challenge for many businesses now trying to cope with the GDPR regulations and trying to disclose that data. So there's been a real shift, I think, and I guess the call today is a good example of where there's so much difference as well in interpretation sometimes across firms. And I have so many conversations. Oh, I'm not going to disclose that email. Oh no, actually you have to. I know. Or I'm not really sure where all our data is. We think this is what it is. So lots of those conversations. So it's a very interesting beast, and I think they're not going away either, Robert. I think they're here to stay and they're here to be used. And I've certainly seen, even I think COVID is a good example. Maybe people are at home now and maybe thinking, oh, I'll get a DSAR in now, because I've seen a certain increase in that side of things as well. So it's here to stay, I feel.
For sure. And we've already hit on some of the sort of top tips, typical errors, and Brexit, which are the three big things we were looking at. The sort of overarching agenda is the top tips, typical errors, and Brexit. And we'll come back to Brexit later on. And we've already sort of started to talk about the sort of the submenu of in-house or external, human, automated, or both, and things, you sort of top tips on what people should be thinking about. So going into the top tips and typical errors for when you actually receive one of these DSARs, and let's just deal with DSARs as one of the DSRs, one of the data subject rights, the access request, which is so actually I've already put it on the website, but formally welcome to Content Captures into the Privacy Stack as a Privacy Stack partner. And when that blogs up on the website, and with the stat that the average cost from Gartner of a subject request is $1,400 of the workflow itself. And there's an example of one that was a very sad one on healthcare that was £250,000 on legal fees alone on one DSAR. And also that access requests are the single largest source of complaints to the Information Commissioner's Office, which was a surprise to me. I would have thought it'd be much more like, telephone calls or security, but 46% on DSARs. So what's your, Shad, if I could ask you first, what's the sort of top tip, typical errors when, at the very beginning, when you get that DSAR in?
Yeah, no, so it's a great question. And you are right. I think I was shocked as well. Half of complaints nearly to the ICO are data subject requests. So it's a lot of work for the ICO and a lot of work for businesses as well. And I think the key bit really, in my experience, is it's a bit of a cliche to start off with, but if you fail to prepare, you prepare to fail. And the important part is really having that preparation and having a process in place. And so you need to kind of look at all different aspects of making sure that the audit is there, the audit trail is there. So, if the DSAR request, the data subject is unhappy, they can go to the ISO. You need to have a robust process to highlight what you've done. And so I think that's where it starts really. I think it starts with having good data governance practices, procedures and policies on how to handle these data subject requests. And part of that also goes into how to evaluate that data, do those data searches. So as a data privacy professional, which I am, it's really highlighting to the IT department, all those people doing the searches, that they can go and do the Outlook searches, and they've got a criteria to do those searches, and that's driven by the process. And part of that, it goes into all different areas. Even the process will be contacting the data subject to ask them, can we narrow this further? What are you actually looking for? And what date frame are you looking at as well? So it's just trying to be really narrowing it down as much as possible. And that again is by process and procedures and communication as well. I think I remember an example where a DSAR came in, one company I was working with, and they literally asked someone to put a request in, they didn't acknowledge that DSAR, and then a month later a document came in, I think it was all paper form, redacted by pen. And the data subject at that time was like, well, it would be great to contact me. One, that they got my DSAR. Secondly, just to highlight, actually, I would want it in a PDF, and I would have narrowed it down and all that stuff as well. So it's just trying to really have that process so you save yourself time. And really part of that also is working upon training staff as well. So can staff identify, is this a data subject request? And I've seen examples where there's a complaint letter and there's one little line saying, oh, can I also have my data, please, or all data you held on me? And it's just making sure that staff can understand and spot those data subject requests, because it's not always written down, oh, under Article 15, can I have my data? It sometimes can be very softly written within there as well. So I think that's very, very important too. And I'll give you an example. I remember there was, you can go to a school and there could be a receptionist or secretary in that school, for example, and they might come in and say, oh yeah, how's Harold? Oh, Harry's doing good. Yeah, it'd be good to get a look at in his file. So it could be the simple things like that, coming from a parent that staff need to be aware of. So I think that all starts from having a robust process, procedures in place, really. And that can be in form of.
That's awesome.
Yes.
I think that training and having people being able to recognize it and when to really formally classify it and to escalate it, having someone that people can go to and say, I think I've got a DSAR, what do we do? And then Matthew, when you're contacted, so am I right? You tend to be contacted when the organization's decided we've got a DSAR here, and then when are you brought in? So this is a bit like the sort of in-house external or automated or not question almost. When it hits on both of those, when are you typically brought into a DSAR, and how many times is that where an organization, I know you deal with a wide range of sizes, your feel on when people go, oh my God, we've got a DSAR, and they come to you with like 28 days gone already, or how many go, we've got a process, here it is, day 2?
Yeah, well, I mean, Shad's absolutely right. The amount of SARs that we receive where it's just one line tucked in a grievance, something like that, and then we see the tittle tattle after that, because once the data comes to us for us to review, we start at that end of the process and we work backwards. So we'll see the tittle tattle where it will be somebody saying, look, is that a SAR? I don't know, what's a SAR? And that can go on for 2 or 3 days. And then there's a sort of a real misunderstanding at the moment about how to actually acknowledge a SAR. And it's important, I think, that companies do that. And like Shad says, start that kind of positive communication approach at that point. Sometimes it's a different person. I mean, often it's head of HR or somebody like that that's got the people skills to actually go back to the person and to negotiate the scope. Right. And we often find DPOs actually, and again, an outsourced service like will.i.am, for instance, would be perfect for this. They're more of a neutral person. So if there's a grievance, which there usually is, or some sort of a misunderstanding, that DPO is withdrawn from that situation, and they can use the process of acknowledging the SAR to build a positive sort of thought process to negotiate that scope. So people will tend to come to us after about 14 days. And in all honesty, quite a lot of the people that approach us have tried to do it themselves. And quite often they do very little in the first 14 days. They'll receive it. Quite a lot of the time we'll argue about who's actually going to be taking charge of it, because quite often the finance director will say, look, it's nothing to do with me. And IT are good for this because it obviously involves a lot of IT searches. They're traditionally very busy people, and they straight away say, this is nothing to do with me. So it gets passed around a little bit. So it tends to be 14 days when it comes to us. And that's even if there's a data protection officer. And it's surprising how many times the data protection officer is quite withdrawn from the process. Strangely, they should be I think Shad will probably agree, really heading it up, but it often is IT or it often is HR that tends to take control of it because they know what the problem is and the angst in there. So yeah, 14 days, but my top tip definitely would be do not ignore it. So if you haven't got the process in place, which Shad correctly recommends, if you haven't got those and it just comes to you, don't ignore it, get straight onto it. Start to work it. Like any problem, as soon as you start to work it, it gets easier a lot quicker.
I think there's an interesting variety out there in terms of if you're sort of a B2B business, pretty well the only DSAR you're going to get is, as you say, like a disgruntled employee, and maybe sort of a couple of those every now and then, depending on how big a business you are, obviously. But if you're B2C, like say John Lewis or Selfridges or what have you, you're going to, I gather that they get hundreds, a month of DSARs that they've got a process that are running through those separate to those employee grievance bits. And then there was just a recent case in the UK about the court being very aware about the purpose of the DSAR, that if it's, as a lawyer in private practice, we used to use DSARs in litigation to get early discovery before the litigation discovery kicked in, which was, and that's been called it's called to question by the recent court case just now in this January, a couple of days ago. So is they're looking at the purpose of it as well. But so this is all fantastic. So going on to then, we've talked really about that sort of in-house external, the ones that obviously you're both external, so you see the external ones, but do you have a feel on from talking to your customers how many they deal with in-house, and whether they send all external or they use a combination for both, or they only send the difficult ones external? What are your thoughts on that?
It really depends on the business. We do universities, for example, of which maybe 75–80% of those are student based, and then they have the HR ones, and they'll just have a split where they just send the HR ones. The student ones, it's as easy for them to do because, to be honest, 95% of the work is actually gathering the data together, running the searches, things like that, and it's a very low document volume at the end of it. So it very much depends, and you can get you know, other companies that have a lot, like you say, a lot of customer related ones, housing associations, for instance, building companies, the house builders, for instance, probably 90% of theirs are to do with the you know, the customer themselves, and they're a completely different project because there's deduplication to be removed from that data, but in all honesty, just about everything, the customer is the focus of the document. That's why it's there. Whereas obviously with HR, with HR related employee ones, there's a lot more just day-to-day business and things like that actually the subject isn't the focus
like
of. Not entitled to.
or this sort of thing.
Yeah, absolutely. So I don't know what your thoughts on that are, Shad, but for me, it completely varies.
Yeah, no, certainly. I think I've seen both sides. So, you know, obviously I've worked as a DPO and I've worked in organizations, and I still do in many ways. So I guess the way I look at it, it does vary. And I think where you have many coming in, and, you know, I work with a company where they had 100 DSARs coming in a month. They had a process in there that could deal with some of those. I think where it gets complex is where you have got a lot of data and you just cannot go through it, and a lot of legacy data. Perhaps you haven't got a retention schedule and you may have kept it, which a lot of companies do, keep their data forever. So I think it can vary. I think where it gets a bit more messy, it's really where you've got employees, and I think that's where an outsourced solution does work quite well, because I remember with my experience, we had an internal employee make a DSAR request, and I think we had 4 full-time staff spend the whole month going through all the documents trying to redact it. So, you know, it cost us a lot of money in the business to do that, and we had people that weren't really experienced in doing it, so they were like, "Oh, I'm not sure what I should be redacting here," and so we worked out the cost of doing that and actually outsourcing it. It worked out a lot more value for money, and from an audit perspective, you know, we kind of thought, well, if this goes to the ISO, we can say we went to a specialist firm. We gave them the data, they went through it for us, and it saved us a lot of time and money. And also there's an external party involved, which is a third party that's got no vested interest. We'll look at it purely independently. So I think that's something that every firm needs to balance up. But also I've got firms that maybe have 1 DSAR a year. And again, they may not have a designated person, and it might be easier for them to kind of outsource it. But it varies. I think smaller businesses might be a bit more easier to cope with them. And if it's a limited amount of data, or if you're a new business, then it may be easy to collate. But I think you just got to look at it individually, case by case. There's no kind of hard or fast rule, unfortunately. And you have to just make that decision quite early on, I would say.
I think that's what makes them so difficult, because there is no hard and fast rule, and it does vary so much. And I think in a way, you know, if you're a John Lewis and you've got hundreds a month coming through, you're going to have mostly it's customers. You're going to have a process, and you just sort of push it through, and you're ready. But if you're one of those businesses that doesn't get many, or you've got the disgruntled employee one, that's when it's really, really tough, because we're not going to go into exemptions any detail or what have you, but you get into all the different exemptions, they really kick in, you get into all the sensitivities. And Matthew, you made a really good point about in the internal, external, actually, who you want to be able to see the information. So could you just go into that a little bit on that?
Yeah, I mean, quite often, I mean, if we look at sort of an example of a SAR, which would be a tricky one, it could be somebody like managing director that's leaving a business. Now, HR, people in HR, certain people in IT would have access to that, you know, that particular person's email box, and the documents maybe in a SharePoint folder, something like that. But very, very few people in the organisation do. And you know, it could be an embarrassing thing, could be fraud. It could be the fact that the business is really struggling in a certain way to do with funding or a split within the board, all those sorts of things that you really don't want to be aired. You know, sort of through the whole structure that might analyse the SAR. So it is good to send it out. And again, I think from, you know, Shad makes a great point there that it's an independent set of eyes. You know, we'll look at it without an agenda. You know, we'll go through it. We will enact what the ICO want. You know, that they want people to be champions of that information, rightly so. We'll go through it from a neutral point of view and just follow the rules. There won't be any agenda, because you do find when you're redacting some of the documents that if you've got a view on it already to start with, it does slightly shape the approach that you take. So to have that neutral approach is often a way. So, you know, again, outsourcing, you know, there are some that lend themselves to in-house. You know, I mean, we're a commercial business. I've founded this business 23 years ago, and there's some things we outsource and some things we don't, you know. For me, the best reason to outsource is experience. You know, Shad says there, 4 people working for a month on a SAR. It takes us about 6 months to train somebody up to work here, to get them up to a speed. where it's a decent commercial speed, but also it's that level of accuracy is there as well, and the speed of interpretation. So experience is absolutely vital in doing that. And then when you blend that with technology as well, that's where the key advantage to outsourcing is the fact that we've got better methods, better software, better technology. But that experience is vital. I work with an absolutely fantastic group of people, and we do 16, 17, 18 large SARs a week, and lots of smaller ones as well. And that experience all amalgamates to make them sort of kind of killer redactors, really. So it's always worth considering outsourcing, I think.
When you get a DSAR, obviously it depends on the volume of documentation and the difficulties of the questions, what have you. Could you give us a sort of ballpark, both of you, in terms of, maybe Shad, if I start with you, in terms of when a client comes to you and says, so there's two different questions, I suppose. So someone might come to you a bit earlier in the process, Shad, and say, I think we might have a DSAR, I'm not sure what to do. And Matthew, I think they'd come to you and they go, here's our documents on this DSAR. So Shad, when someone comes to you and says, I think we've got a DSAR, what do we do here? Can you help us through? What's your ballpark time period in terms, I know there's 30 days and it could be, 30 is a weird month calculation, isn't it? But it's a month and then it can be extended. What do you tend to see as the ballpark time frame on the responses?
Yeah, so I work very much on the basis that you've got 30 days to do this. And the reason why I say that is because when you look to extend, it is very subjective, and you really have to be able to stand in court and say, this is the reason we need to extend. And we have seen cases that have been extended, and some of them actually, we've got legal advice on it. Said, this is so complex, there's so many compliance issues here, or other issues with this individual that he's made various complaints that we'll have to go to get some legal advice, and that took a few weeks, and then we had the justification to extend it on some occasions, and the ISO came back and said, well, yeah, we don't think as a big firm like yourself, this is viable to be extended, and you shouldn't have extended it. So I think the ICO do take it case by case, but I always look at it, guys, we've got 30 days to do this, let's do it in those 30 days. If you look to extend, ideally you want to try to get as much data you've got within those 30 days, and if there's other data which needs to be get from a legacy system or archive system, maybe supply that as soon as possible after the 30 days. I think where you have to be careful is on day 29, I'm going to extend it here for 2 months, but it's quite a straightforward request, and you kind of think, well, is this warranted? So I think every business is really got to look at the guidance from the ISO and say, is this really justifiable? And also we've got to be careful. Listen, you don't want to hack off the data subject, because by extending it, it's another 2 months. They will just go more likely to go to the ICO. They're going to be more frustrated. Why are you doing this? And they're already probably not upset anyway, because they're probably putting the DSAR in for various reasons. I think you just got to be very careful. So I always advise the business, we've got 30 days, let's do whatever we can to get it within those 30 days and have that communication. So if it's suddenly we're on day 30, but we're nearly there, we need another few days, that's something like, sorry, we're a bit behind on this, but we'll get it to you in a few days' time. Most people will be happy with that. So it's just working along those bases, I would say, Robert.
I think that ties into what you particularly said earlier and Matthew said as well, which is, I really liked what you said earlier about establishing a positive discussion and actually dealing with this positively with the individual. And Matthew, you were saying, someone who does that is maybe the person with the skills to do it more human way. And because I think there's a fear that, you can't talk to the data subject, and it's, the ICO has clarified that you're totally entitled to say, do you want everything? Do you want it just about this particular dispute? Do you want it about your activities as a customer for us, or do you want it as the employee as well? Because it might be an employee and customer. And now they don't have to narrow it down, obviously. They can just say, no, I want absolutely everything, but you're totally entitled to say, what are you looking for here? Matthew, when someone comes to you and they say, here's our data, and then you carry out the DSR, sort of, you investigate it, you redact it, and you provide them with pretty well the finished article for them to review. What's that typical time frame, if there's a way you can give a ballpark on that? Obviously, there's some factors that maybe you could go into that affect that.
Yeah, good question. I mean, the most important thing with SARs is every single one's different. I mean, we've broke them down into customer ones, HR ones, which is the correct way to do it as a broad thing, but they're all different. So the first thing we want to try and do after about 7 days is to be getting hold of the data. The way we price and work these things is we do what we call a free of charge, no obligation quote. So because everyone's different, we'll take the data in, we'll look at it, And at that point, we'll give a fixed delivery date and a fixed price. We know those two variables at that point. So providing people want to move forward, at that point, we start to deduplicate the data. We start to run some AI through it, some machine learning in terms of things like regular expressions to try and give us a head start on these things. But ultimately, it's still a very human process for lots and lots of reasons, be it misspellings, nicknames used in there, formatting of the text. And you also tend to find false positives coming in, which need to be taken out very, very carefully. If there is angst in the situation, the last thing you want to do is provide somebody else's data to somebody at that point and create a breach. So, the false positives. So we'll take around 7 days at just really crunching the data, to use a technical term, and then the human eyes take part with it. And we need at least 3 sets of human eyes going through it, because we find one set of eyes picks up certain things, second set of eyes will take a slightly different slant on it, and then obviously we need a managerial overview on certain things just to pull it together. So that's another 7 days. So that's about 14 days that we need, and that would include QA at the end. And as Shad says, and the ICO are absolutely right. 30 days should be enough. Time. I mean, we deal with some quite eye-watering numbers. Just a blue chip client of ours at the moment's just dropped 135 gigabytes of data on us, comprising of almost 2 million search results, and that we can still do in 2 weeks. That's something that we can process in 2 weeks. We don't have to read 2 million pages. Because obviously we've got duplication in there, we know we've got false positives, so we'll start to bring these things down. And these aren't off-the-shelf softwares that we use, these are things that we developed. So that gives us that advantage to be able to pull that right down. And, that's a big SAR. That's right at the top end of the scale, but it's still doable. We think the extension time really is for, like Shad says, if it's a legacy system that needs unlocking, it might be in a backup tape that needs some specialist expertise to be able to get to. That's probably where the extension comes in. If you're a decent business that's prepared properly, put your steps in place now. There's no reason why we can't hit those deadlines. So yeah, we need about 2 weeks in the middle. Sorry, one last point there, just to quickly make. The reason that we leave that time at the end is to review it. And that's really important time, as Shad will tell you. That's possibly when you might need to take a legal opinion if there's some before we lead on to exemptions, or you might just want to just go through it and just double check yourself, because it's your documentation at the end of the day. If you've outsourced it to a company like Content Capture, that's fine, but you're still the data owner. You're the person that's going to be passing that back. So you just need that little bit of time to review. So ideally, a week just to line your ducks up. 2 weeks for us to do our bit, and then a week to review it at the end, and everything should be perfect for the data subject.
Yeah, I was going to say, just in regard to Matthew said, yeah, totally. I think you need a bit of time in the end to review it, make sure there's nothing within there from a commercial point of view that shouldn't be disclosed in there, or anything subject to legal privilege, anything along those lines. And also sometimes, if you've got grievance procedures or disgruntled employee, that may go to legal action. So you just want to make sure that the legal teams internally or externally have a chance to review that if there is a secondary issue with this DSAR, because it may be used as a potential data gathering exercise. So I think it certainly is important as well. And I remember, I'll give you a good example actually, where we had to extend it a bit longer than the 30 days is because we done a DSAR for this customer, and we sent it electronic format as we done with this particular customer. But what happened is, the family came back and said, actually, the person who's requested a DSAR is in prison. So I said, well, obviously we can't deal with you. We can have a letter of authority. So we got the letter of authority. And what the customer was saying, look, I'm in prison. Electronic format doesn't work because I can't access my emails. Can you print it for me and send it? And so obviously it's one we thought about, and it was like, well, he's got the right to the data. Okay, we have to just accommodate that. So I remember we had to print it all off. And then, it was weird addressing it to the prison, Her Majesty's prison, the customer, but that's his data, he's entitled to it. And if he wants it in that format, that's what we had to do. So we went just slightly over 30 days.
Did you have to hide it in a cake, Shad?
I think so, man. I don't know how we got it.
Delivered it by drone.
Yeah, we had to send it. But yeah, it's an interesting one. So you get all different scenarios sometimes. So that was one interesting way. We just had to think out of the box, print. It was a big file. I think it was 1,000 pages in the end. And we just had to redact it manually and just print it off manually and do it that way. But it was what it was, really. So yeah, just got to be.
And I think that's a great example. I think what you've both what's come through on all of this is, it is that whole truism of people, process, and technology. So when we've talked about in-house and outsourced quite well. In terms of the automated and human, I think we've also covered that pretty well, because I think you're absolutely right. You can't have a pure automated way, because you just don't know if you're going to be letting something out that is, something. Obviously, if it's embarrassing to the organization, that's not relevant. You still have to release that. But if it's something that's legally privileged, or it's some third party's confidential information and it's not personal data, you don't want to access. So a lot of people make a mistake, I think, of thinking that it's the document itself that you have to send out. So if it's an email to Robert's copied on it, then it's Robert's personal data and he gets a copy of the email. Well, no, because that doesn't relate to me. And some of the errors I've seen is where people have inadvertently released not just so much the personal data of other people, because they seem quite aware to that, live to that. Be interested in your comments. The mistake I've seen a lot on release DSARs is releasing excuse me, confidential or strategic data of that own company or their partners. I don't know if you guys, what you think about those sort of typical errors on the way out of the data.
Yeah, it's a good. Yeah, go on, Matthew, after you, mate. I'll follow you, mate, from now on. I'll let you go first, mate.
Yeah, I mean, every sale is different. I mean, we tend to take a lead from the client, who takes a lead from their legal advice. So quite often things like customer names and things like that will be, will be removed. Any amounts, numbers, things like that will be removed. That they tend to, as long as it's something that they can justify to the ICO to be able to say, look, we've taken a strategic decision to protect our business, which you are entitled to do. And again, the data subjects request, like you say, it's where it relates to them. It's where they're the focus of that information. It's not necessarily any document that they're shared with. Where we tend to find a problem is there's lots of ambiguity. I mean, we've got probably out of the the FTSE companies, we work for over half of them now, and the different interpretations that they've received from people at the ICO. And again, there's no blame attached to them at all, because they're trying to do their job in the best way that they see fit. But it's that interpretation. So we take our lead from the client, and you'd be surprised how many clients say, look, we want a common one at the moment, for instance, is with colleagues' email addresses, is to leave anything after the @ sign in. So say, for instance, it was Matthew at contentcaptureservices.co.uk. They would say leave contentcaptureservices.co.uk, but redact Matthew from that document. Other people say no, leave it all in. If it's known to the colleague, if they've possibly seen that email before or something like that, leave it in. And other people say, look, we can't QA that. We're just going to take a broad approach. We're just going to take all of it out. And that could be three, blue chip businesses, all with a different interpretation of the rules. So it is quite difficult in terms of knowing what to do there. And I would imagine as case law comes forward and as this process goes through, and again, we'll touch on Brexit and maybe some of those changes and how UK Data Protection Act starts to sort of interpret these things. But I'd love to say over the course of the last 18 months, it started to head towards a point, but it's not. If anything, it's still splayed out there, with different interpretation.
Yeah. I mean, the cases are starting to come through now with these. I think it's a bit like breaches. There was a delay in the breaches because it took time for the breaches to go through the commissions, the various different regulators around Europe, and it started to really flow through now, the fines. But in terms of DSARs, I think the UK Information Commissioner only released its updated guidance in October last year, which was 18 months after it came in. So there's even more actually. So it's like 2.5 years after it came. So I think we do have a long way. It's very interesting that I think it shows how subjective it is, and also how important, as you both said, about having a documented reason about why you came to that decision. And I think as long as you've got a reasonable documented position, I think you're in a good place. And in a way, it's a bit like in the employment tribunal when they look at, they don't say there's only one possible outcome. Is it within the range of reasonable possible activities of an employer? And in a way, when you're responding to a DSAR, there's not one right answer sometimes. Obviously, there are some rules where there are, but there's a lot of gray areas where as long as you've thought about it, respected the individual, and there's loads more we could go into in terms of, I mean, I don't totally think from what you both said as well, just very quickly, before we go on to Brexit in the last 5 minutes or so, my feeling is very much that organizations are really wanting to do the right thing by data subject requests and are wanting to be compliant. It's just, it's so difficult and there's so much and there's that time frame. What's your feeling on that?
Yeah, I mean, my experience is that organisations do. I mean, obviously, it's a cost, you know, and quite a sizable cost, and there's nothing that can set against it in terms of profit necessarily. But it is something as we develop in time. I mean, you know, the celebrity will.i.am, who I think I've mentioned before, is an absolute nightmare for us to redact. I mean, it's another example why you would need human input. If you tried to redact, then will.i.am out of documents, just about, you know, to just every page would be covered in redaction marks. But I've just got a quote here from him. He says, "I am not my social security number. I am not my driver's license. I am not my passport. I am who I know, where I go, where I've been, and that is who I am." You know, and your data, you know, he regards personal data as a human right, you know, just like access to water, for instance, and the ability for people to own and control their data should be considered as a central human value, you know, and I think that's where we're going. It's the value of data. So I think companies are embracing this to start with, and to say, look, let's be champions of this. It's here. You know, let's look for the positive reasons. Where I feel sorry for them is when the subject access request is put in as a punishment. You know, an employee's left the business for whatever reason, and they just want to beat that company up. They want to give them a cost. So there's no scope going to be negotiated. I want everything, you know, and it's just to beat the company up. And I feel very sorry for businesses like that. And we deal with an awful lot of charities, some of the biggest names in the UK charity sector, and there's thousands of pounds leaking out of their pockets every year to, you know, for ones that I don't think are in the spirit of it. So if I could be too bold to suggest anything to the ICO, it would be possibly to look at those sorts of cases and say, you know, maybe that's not in the spirit of it. Because I'm with you. I think businesses are really trying to embrace this, and organisations are really trying to do the right thing, you know. So that's the change I'd make. Shad?
Yeah, I'll just quickly add to that. Really, I know we're going to go into the Brexit side of it, but yeah, I think you're right. I think businesses do want to do the right thing, and I think there's certainly they don't really want to put their head above the parapet under the ICO as well. That's also a factor. I mean, and we know DSARs, you know, if half of them are going to the ICO, as a business, the ICO do look at these. If a business is suddenly delaying, going over the 30 days continuously, similar complaints coming in, the ICO will pick up their ears and think, hold on a minute, is this business compliant to the GDPR regulations? You know, ICO are very limited in staffing, so they will start chasing these repeat requests. I think from this point of view, yeah, you have to get it right. Of course, you want to do the right thing. You want to make sure customers are happy. You don't want the reputational damage or the regulatory damage, but also you need to make sure your records of processing is right.
Yeah.
You need to make sure you delete that data. So when you do a DSAR, you make it easy for yourself. It's only a limited amount of data. You haven't got data going back 20 years, stuff like that, really.
Yeah, I think that's another good point. So we could go on this for ages. It's fantastic. I knew it was going to be a fantastic conversation. So we've got 5 sort of minutes left. We can maybe go a little bit over. But on Brexit then, I mean, obviously, you know, the three of us were in. Well, actually, Shad, I don't know if you're in on the continent at the moment, but the three of us, you know, it's UK sort of businesses, but obviously there's the UK GDPR now and the EU GDPR. What do you feel? Maybe Shad, if I come to you first on this one, the impact of Brexit is, if any, and how big it is on DSRs for people?
Sure. I think it was a lot of holding breath, and then I remember Christmas Eve. I remember it well because suddenly there was the trade deal came on the table, and that really helped a lot from a data protection perspective, because suddenly now we had a bridge mechanism, which allows us 4 months, maybe up to 6 months, of us to get adequacy, or the UK to get adequacy, which would certainly help us moving forward. So I kind of feel, and I hate to put my hat on this, but I kind of feel that within that 6 month period, the UK will get adequacy. It's unlikely they wouldn't. Yeah. So this whole mechanism is there for that. So I kind of feel moving forward, that would just allow us to share data freely with European, as it has been pre-Brexit. I think where the changes come into effect is, obviously now the European Data Protection Board would make those changes and those updates on GDPR. Now the UK is a separate country. We've got a separate UK GDPR now. We are now no longer legally bound by those regulations. So we would, over time, go certainly up a different course if we don't. I don't imagine us copying every single rule from the European regulator. So
I think that's right. And Matthew, have you seen any? Have you had how much of an impact? I mean, we're only a couple of weeks into January, but in terms of executing on those DSRs that come to you, how have you seen Brexit rear its head at the moment, or is it something? How are you looking at that?
No, to be honest, COVID is sort of all consuming at the moment. You know, obviously there's different ICO tolerance at the moment for the 30-day thing. They understand that companies have got stretched resources, and in all fairness, it's completely squeezed the Brexit thing. Possibly the only good thing about COVID is it's sort of pushed the Brexit thing slightly out of our consciousness. So I don't think it's going to affect that. Like Shad says, I think we've got that little window where things will just carry on as normal for now. And, you know, if anything, I think we touched on it earlier in the conversation, I think that other things will push SARs, you know, more kind of commonplaces as time goes by. You know, I don't see Brexit being a huge issue at the moment.
Yeah, I was going to just add to that. I was going to say, in regard to DSARs, I guess the key bit is really if you've got European customers, then you need to have a representation in the EU, which then just means you need to have someone set up that can, if DSARs do come in, the European clients, that they come into you. So it's just really having those kind of GDPR-like mechanisms in place, and so that's things that businesses do certainly need to consider. And so that's probably the major thing or the major change, and vice versa. So European clients that have UK clients will need to have a data protection authority registration and also representative in the UK. So that's probably the biggest change, I think, with regard to DSARs, to making sure that that's in place.
I think that's a very good point, because they need to contact that person. If you're not there, then the representative's there to be contacted. And I think because the EU GDPR and the UK GDPR are identical, apart from cross out EU and write UK pretty well, and all the rules on DSARs are the same in the UK GDPR and the EU GDPR. So again, following it at a sort of strategic level, and the rules are all the same in the GDPR. And then when it comes down to the guidance, I don't think there's anything in the UK guidance that's particularly controversial, apart from stopping the clock in certain. They've changed their position into a more commercial, practical one. It'll be interesting to see how that comes through. We've hit our time and we're slightly over, but this has been absolutely fantastic. I knew it would be. Maybe we'll do another one on this because it's such a great topic. Shad, Matthew, thank you so much. And as I say, this recording will be up on Privacy Kitchen and YouTube channel in the next few days. But thank you very much, Matthew and Shad. Really appreciate it.
Thank you, Robert. Thanks everyone joining.
Bye-bye.
Thanks very much.
Bye-bye. Good luck.